We will be waiting for about 4 or 5 minutes, right? And then we will be starting the session. And however, the full session will be a 2 hour session. Um, and first and foremost, I must thank the Training Hub Asia in providing this platform in collaboration with Mindful Contract Administrator to uh, perform these sessions, this series of CPDs, which will be useful not only for a fresh graduate or a university student or an academic, but also will be useful for the practicing quantity surveyors, contract administrators, as well as the engineers, architects, and anybody who is interested in this sort of practice in the construction industry, right? Um, a little bit of an insight about today's session. As we have planned, we are going to have the first session today, and then after that, after 2 weeks, just after the Christmas, right, we are going to have our second session, which will be the second session pertaining to this drafting lump sum contract session that we are having. The session is basically based on FIDIC, but sometimes I may have to derail in order to give you a more comprehensive guideline as to how the worldly the people who the drafters of standard forms of contract will think in a different way, such as JCT standard forms of contract, as well as the NEC, that is new engineering contract, that we are familiar with, right? Most of the academics are using that one, as well as the practicing quantity surveyors in the UK region, right? And medium is both English and Sinhala. At the end of certain milestones within the presentation, I'll be giving you a narrative, but it is not going to be a total reproduction. It is not productive to have a total reproduction of the English session that I'm doing. However, I'm doing a small a summary of what I'm doing in our mother tongue. So I feel so that is it, right? So I think we can start the session now. As we go on, there may be certain other joining people who will be joining. And the good news is, if you have missed this session, or if you are joining later on, or if you have something in between, you'll be getting the recording pertaining to this today's session, right? So as it says, it is drafting a lump sum contract using FIDIC Red Book 1999 and 2017 versions. For the users of SBD2, Standard Bidding Document 2 in Sri Lanka, you can say that is SBD4 is, as I have always told, that it is a twin brother of FIDIC Red Book 1999 version with some amendments. However, so whatever is applicable to FIDIC Red Book 1999 version can easily be transformed or read in that particular language as well, right? So I think your time is 7 o'clock now, and the time here is 5:30. It's not that sunny, a little bit cool. We call it winter, but it is not a winter in Oman. We are coming from a very hot weather. Anyway, so let's start the session today, right? The agenda. I will briefly go through the agenda of today and the day two, which we will be meeting after 2 weeks. So today's session will be basically focusing on 4 areas. That is the history of lump sum contracts, how it has been formed, and how the word lump sum has been originated, and how it came to practice in the construction industry. And then we are going to talk about the features of lump sum contracts, right? So this word lump sum is of utmost importance because it is the cynosure of our two sessions. So it is the term that we are going to talk about. So we should be knowing all the ins and outs. We should study this to the rock bottom in order to have a proper insight about lump sum contracts. And we are going to go into more serious stuff afterwards, that is to differentiate between other procurement and payment mechanisms and lump sum contracts. So you might have wondered why I use the words procurement and payment mechanisms rather than contracts. Actually, even though we call this as lump sum contracts, lump sum is a concept, right? Lump sum is a concept. Now, different standard forms of contract look this in different ways. Now, for example, if you are talking about the Joint Contractors Tribunal, they call something with a BOQ with firm quantities and BOQs with approximate quantities. So there is some concept which is going on. That is why rather than using the word contracts, when you are comparing the lump sum contracts with other form of practices, I use the word procurement and payment mechanisms. And once we go on, you will understand what I am saying here, right? And then the fourth one, the FIDIC 2017 Red Book approach in drafting a lump sum contract. As we all know, there are particular conditions of contract. The only difference between FIDIC 99 version and 2017 version is that special provisions A and B has been named as the contract the contract data and special provisions in FIDIC 2017 version, as opposed to FIDIC 1999 version has got special provisions separately, right? So there are amendments to clauses such as clause number 8, 13, and 14, and their effect. So with that, we are going to wrap up day one because it is going to be a 2-hour session. But in the day two, we are going to talk about the FIDIC Red Book approach in drafting a lump sum contract, in deletion of subclause 12 and its effect. As you know, the subclause 12 is one of the lengthiest clauses. Actually, it's clause 12, not subclause 12. One of the lengthiest clauses appearing within FIDIC Red Book 2017, because now we know the variation has been subdivided into two parts. One is called variation by instruction. The other one is called the variation by request for proposal. So we are going to talk about them as well, right? So subclause 12 is dealing with the payments in this area, right? Payments related to the measurements and all, it is going to be discussed. And then the risks in the context of remeasurement contracts and lump sum contracts will be discussed, right? The aspect of risk is of utmost importance in order for us to understand that as well. Then the lessons learned from a remeasurement contracts and lump sum contracts in mindful contract administration. So there are things like when we are doing a cost value reconciliation, how we address in a lump sum contract and how we address in a remeasurement contract. So when we are doing a payment or when you are doing a valuation, how it addresses, we are going to talk about that. And there are certain case studies which is spanning between both days, and then we are going to have a two-way discussion on the second day as well, right? The journey so far. So mindful contract administrator has embarked our journey with the Training Hub Asia. Our first session was on 29th August 2020. It is on new approach for administering disruption in construction contracts. That was our first session. It was a CPD covering 1.5 hours. And then we spoke about the dice of cost plus profit 2000 using FIDIC Red Book 2017 version. That was also a very successful session. We had 2 sessions in that one. And then managing risks in cost planning using NRM1. We had 4 sessions related to that one, and we recently concluded. So this is going to be the last session in this year, even though we started in August. Every month we have been planning to deliver certain fruitful sessions for our practicing quantity surveyors and contract administrators, right? So the learning outcomes. Today, we are going to have 6 areas focused on in order to attain certain, we are going to enlighten our knowledge. We are going to brush up our knowledge, because I know there are a lot of practicing quantity surveyors who have got this knowledge, and we are going to align we are going to align our thoughts of this particular concept. Number 1 is called the understanding of lump sum contracts and their definitions, right? So that we need to first and foremost understand before proceeding, right? This is the foundation in order to comprehend what exactly is meant by a lump sum contract, and what are the different versions of definitions in the global context related to this particular area. Then we are going to do a comparison of lump sum contracts with other procurement and payment mechanism. So once again, I am using, this is for the second time I am using this one, procurement and payment mechanism. Now, then you must be worrying about that, what these are. We are going to talk about remeasurement type of contracts, right? Then we are going to talk about GMP contracts, right? That is called guaranteed maximum price contracts, so on and so forth. There are different types, other contracts, the procurements and payment mechanism, which we are going to talk when we are when we are comparing this with the lump sum type of a contract. And then we are going to have a case study on cost value reconciliation using a remeasurement and lump sum contract, in order for you to understand how it behaves in two different ways, right? And then we are going to talk about, we are going to learn about the features of FIDIC Red Book applicable to lump sum contracts. As opposed to JCT, we don't have a separate standard form which is being issued by FIDIC for the lump sum contracts. So it is going to be a particular condition of contract that we normally apply within the FIDIC, right? It is the one fits for all type of a standard form of contract when you talk about FIDIC 2017 Red Book. And then we are moving on to drafting a lump sum contract using FIDIC Red Book. So how you are going to draft that one, how the changes pertaining to the provisions made within the special provisions, right? We call them the particular conditions in the older FIDIC versions, and how it goes. And then brushing up some areas of Royal Institution of Chartered Surveyors core technical competency called commercial management in construction, right? Commercial management in construction has been in existence for a longer period of time for a practicing quantity surveyor, right? Especially this is very important for the contractors when they are doing that one, but it is of importance for the consultants as well as developers as we go on within the construction construction practice, right? Then we are going to talk about the four documents that we are going to refer. Actually, today we are going to confine ourselves to the four documents, which is called the code of. Somebody has said that they can't see the slides. 1 minute. Just sent in 5:45. Can others see the slide? Right. I just wanted to know. Can somebody send a message saying that you can see the slides? 1 minute. I'm getting a message. Yes, we can see, right? Yes, we can see. It's good, right? I think that gentleman who raised the query related to the slide issue, just double check, refresh your computer. Perhaps you will be able to see. Thank you for that message. Right. So we are going to talk about the conditions of contract for construction issued by the FIDIC 2017 version. And then RICS new rules of measurement. Once again, we are going to talk about NRM 2 because today I'm going to cite an example using NRM 2 BOQ, right? It may be a new experience to some of us because NRM 2 type of BOQs are not being commonly used in Sri Lanka and even in Oman, right? Because I know my viewers are from Oman and Sri Lanka mostly, right? And then we are going to talk about the commercial management of construction, the guidance note, which is issued by the Royal Institution of Chartered Surveyors. And there is something called Code of Estimating Practice, which was issued by Chartered Institute of Building, right? CIOB, Chartered Institute of Building, has issued a Code of Estimating Practice. Some of the definitions are stemming from this particular document as well. So this is how the documentation part will be covered within today's session, right? Now, what is a lump sum? So this is our prime concern today, right? If you take the harbingers or leaders in dictionaries, if you ask from a layman point of view what a lump sum is, It says a single payment made at a particular time, as opposed to a number of smaller payments or installments. So this is how a common man will think about a lump sum, right? It is a bag of money. It is a lump of money, right? Which will come into that part. Now, the Cambridge has come up with some examples. It says she received a lump sum of this many number of euros, and the paid taken as a lump sum, the entire amount can be taken as a lump sum. Now see the third example. It says if the pension is small, it may be paid as one-off lump sum payment at age 65. Now the word one-off, right? One-off is an adjective which has been used in front of the word lump sum, right? So it can be one-off lump sum, okay? It can be a series of lump sum payments, right? So when you think about the lump sum, it is not necessarily meaning, especially in the construction perspective, that you are going to pay all the things once the building or the bridge or the tower has been completed, right? So that notion has to be eliminated from your mind at the beginning, right? And let me plant the correct seeds of the word the lump sum as applicable to the construction contracts from now on, right? Now, in 1898, that is towards the end of the 19th century, okay, there was a there was a contract signed between a person called Sumter and Hedges, right? The agreement between Sumter and Hedges was, right, he will build two houses. Sumter will build two houses and a stable. Now, since this is a Christmas time, I used this picture with a stable with the Christmas bells and some decorations as well, right? So now what you see here on your top right hand corner is an old British type of a house. So in the 19th century, if you watch the movies or if you see the Google and all these things, so these are the types of houses which were constructed in the UK. You can see that the roof is of more angle in order for the snow to fall down, right? And you can see a lot of bricks, right? And then a traditional type of a house which will which will enclose the dwellers within the house from adverse climatic conditions as well, with some apertures. Those are the windows which is at, right? So Mr. Sumter, in 1898, the case was held in 1898. Mr. Sumter had an agreement, a contract with Mr. Hedges to build two houses and a stable. Okay, a stable, as you are aware, is a place where horses are being kept, right, and fed. So these are the stables which we know, right? I was quite surprised when I saw these figures. It says for 560 pounds, right? In our terminology, it is actually about 280 riyals. You can multiply it by 500 and get the value of rupees at that time. So this was an era where actually it is 100 years ago, 120 odd years ago, a house, two houses and a stable was costing 560 pounds, right? So he did work valued at 333 pounds. So from the first instance that you can see, Mr. Sumter has not completed the whole of the works, right? So he did the work which was valued at a 333 pounds, right? Substantial payments on account, right? Now this comes into your mind. What is on account? On account payment is a very familiar word for the quantity surveyors who are practicing, right? On account payment have in fact been made to the builder. So that means there was a lump sum contract which has been agreed, and as the work progresses, it's like you are giving some sort of a money, right, to the builder, right? Hedges finished the building, right, using materials which Sumter has left behind, because the Sumter did not finish the work. So the basic idea which comes into your mind is Sumter did not fulfill the contractual obligation that he had with Hedges. Okay. However, Hedges finished the building, maybe using another contractor or something, using materials which Sumter has left behind. Sumter sued for the outstanding money. Now, Sumter did not finish the work, which is worth, as per the contract, for 560 pounds, and he was asking the balance money from Hedges. Then the judge found that Mr. Sumter hadn't abandoned the contract. It's the second word which comes into your. The first we were talking about on account payment, right? And then we were talking about abandoning the contract, right? Some say suspension, right? Abandoning the contract is a little bit of uh, 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 a more complex situation than suspension. Suspension means that you temporarily stop the work. Abandon in the sense that you leave the work, right? So, and said he could obtain money for the value for the materials, but nothing for the work. Okay. Now, this is where one of the law cases pertaining to a lump sum contract has evolved in the British system, right? And then the question was twofold, right? When you see the facts, the question was twofold: whether the partial performance of the contractual works are an entitlement for an employer to pay for the value of work done. All right, we are talking about a lump sum contract here. And was there a right to recover the value of the work separately? Okay, so those were the two things which came into mind, right? And then the judge decides, the court held that under a contract of work for a lump sum payment, again it says lump sum payment, the contractual price cannot be recovered, neither the whole nor in part, until the contractual work is complete, right? This is what you sign as a uh, standard form of agreement, right? When you are signing a contract agreement, you remember there we use the word, the adjective called whole of the works, right? We are not saying part of the works, right? So in a lump sum contract, okay, irrespective of the standard form which is being used, it says it is a all of the works that you are going to complete, right? If the work was completed yet within certain omissions or defects, then the employer would take the benefit of the completed of the works, and the employee would be entitled to payment of the contract price with deductions. It says with deductions. However, right now there is some sort of a subjective term which is used here. However, on the facts, that means, what are the facts? Sumter did not finish the work. He left some materials at the site and he went out of the site and he abandoned the contract. However, on the facts, the employer abandoned the contract without completion. It says employee. The employer and employee are the words which has been used in this particular contract. Not like the employer and the contractor that we are using in the FIDIC form of contract, or client and contractor that we are using in the JCT form of a contract, right? This partial performance, again, the third word which comes into play, the partial performance of the contract works does not entitle the employee to recover any payment of the contract price under a lump sum contract. So it is a very important term that the judge has held, right? Secondly, that is number one, right? Secondly, the court held that alternatively, quantum merit payment would require the inference of a new contract for the partial work, independent from the lump sum contract. Okay. Yet, on the facts, there is no inference of a new contract for a partial works. Okay. As the only applicable contract is the lump sum contract, the employee was not entitled to recover the contract price for his partial performance of the contractual works, right? Therefore, it is a very clear thing. It is an inherent feature of a lump sum contract wherein there is no payment mechanism in the early days, right? Now there are ways and means for doing evaluation, right? How the payments will be done. But in the early days, now you can see This triggered the significance of a performance bond, right? Had there been a performance bond at that time, right, that performance bond would have been encashed by the employer, because the contractor did not honor the contract, right? The judge held that in a lump sum contract, since the fulfillment of the total whole of the works has not been done, right, there is no eligibility for a claim, even though the quantum merit principle suggests something to be paid. This is why it says, right, even though there is a quantum merit payment would require the inference of a new contract of partial works, which has not happened. Okay. Quantum merit, in the sense, it is a Latin term which says as much as he deserves, or as much as he worked. So normally this particular principle comes into play when there is a letter of intent which has been issued by a particular employer or a client, right? A letter of intent is a term which is stemming from English common law, and English JCT type of contracts, because in FIDIC form of contract, we don't have something called letter of intent. We have something called letter of acceptance, right? So whenever there is a letter of intent which has been issued, and a contractor has done some work, but due to some reason, the contractor could not complete the work, right? Then this quantum merit principle will apply, because if this principle has not been applied, the gentleman who is getting the partially finished facility, okay, partially finished facility, is enjoying something which he has not paid for, is enjoying something which he has not paid for. We call it as unjust enrichment. Okay, so those things are some legal principles which is appearing within the English legal system, right? Quantum merit means payment in proportion to amount of work done. Generally, one cannot claim performance from another unless one has performed his obligation in full. Now, this particular red-colored portion of the quantum merit principle has been violated by that particular gentleman, because he has not fulfilled his obligation, right? It was not beyond his control, or it was not beyond, or not based on someone else's fault. It is because of his fault. The person who has signed the contract in order to complete this particular work did not complete the work. Therefore, one cannot claim performance from another unless one has performed his obligation in full. That is why the essence of this particular legal case is of utmost importance for a lump sum contract. Unlike a unit rate type of a contract, okay, that I will come to that separately, right? But in certain cases, there are always exceptions. A person who performed some work under a contract can claim remuneration for the work which he has already done. This is where a unit rate type of a contract comes into play. You know that if there is a BOQ, right, which is driven by the measured works, right? Measured works indirectly says quantum merit, as much as is worked. Okay, you will be paid based on the measure and value basis. Now in Sri Lanka, we are using a term called measure and pay. Okay, measure and pay and measure and value are both aligned with each other. They are going hand in hand, and they are the same, right? The right to claim on quantum merit does not arise out of contract as right to damage does. That is also important, because there is a damage which has occurred to the employer because of the non-fulfillment of the contractual obligations by the contract. It is a claim on quasi-contractual obligation. I think you might have heard of this quasi-contract. It is an arrangement between two parties who have no previous obligations to one another. It is created by a judge to correct a circumstance which one party acquires something at the expense of the other. So this is some legal terminology, which I don't want to go into more depth, but I just wanted to say that just because somebody has partially fulfilled a work pertaining to a lump sum contract, it does not entitle that particular person for the payment. So this is one of the inherent features of a lump sum contract. Right. Now we are going to go into what is a lump sum contract, right? The Code of Measuring Practice of Chartered Institute of Builders, right? Chartered Institute of Builders says lump sum contract is a fixed price contract. So whenever you are saying lump sum fixed price contract, you might have wondered why we use the word lump sum fixed price. Is there anything called lump sum not fixed price or something like that? Yes, there is an answer for that as well, right? You might have heard about the price fluctuation clauses, which is also appearing in lump sum contracts. We will discuss about that separately, right? Lump sum contract is a fixed price contract where contractors undertake to be responsible for executing the complete contract work for a stated total sum of money. This is what the Code of Estimating Practice in CIOB says. Now let's think about the RICS version. This comes in the Commercial Management of Construction in RICS, the guidance note. It says a lump sum contract where a fixed price, again, the same word has been repeated, subject to contractual variations. Now, the RICS went into the extent, it says indirectly, yes, it is a fixed price, but the variations are possible, right? That is why when I showed you the first two slides, I did not delete the clause 13 totally. Clause 13 is related to the words variations, right? Clause 13 only there are amendments. It is not totally changed. But clause 12 has been totally deleted from a remeasurement contract to a lump sum contract, right? Therefore, contractual variations are possible in a lump sum contract. But it says fixed price is tendered and agreed for a contracting organization to deliver a project. The fixed price is usually arrived at through the computation of bill of quantities or activity schedule. Right. If you see the Joint Contractors Tribunal, the latest version, which was issued in 2016, has got three standard forms of contract, which I'm going to discuss separately. BOQ with quantities, contract with quantities, standard form with quantities, without quantities, and approximate quantities. They have been designed for different purposes, and I will be discussing that as well, right? මම දැන් කෙටියෙන් පැහැදිලි කරනවා නම් lump sum contract එකක් කියලා කියන්නේ අපි price එක fix කියලා කියනවා. හැබැයි ඒ price එක fix කියලා කියන එකෙන් අදහස් වෙන්නේ නැහැ contract එකේ variations තියෙන්න බෑ කියන එක අදහස් වෙන්නේ නැහැ. ඊට අමතරව අපි සමහර වෙලාවට price fluctuation clause එක insert කරොත් සමහර වෙලාවට ඔය කියන fixed price එක වෙනස් වෙන්නත් පුළුවන්, right? හැබැයි lump sum contract එකේ essence එක එහෙම නැත්නම් lump sum contract එකේ revolve වෙන basic idea එක තමයි price certainty කියන එක. Price certainty කියලා කියන්නේ you are certain about the price that has been signed for a particular amount of work. Like that අපි හිතමු ඕගොල්ලන්ගේ වාහනේ හොදන පුද්ගලයා කියලා. අපි ඒ වාහනේ හොදන පුද්ගලයාට අපි දෙන්නේ lump sum contract එකක්. මොකක්ද අපි කියන්නේ? අපි කියනවා right ඔබ මගේ වාහනය මාසයක් හොදන්න. එතකොට ඔබට ඒ කරන රැකියාවට මම මාසයකට රියල් 10ක් ලංකාවේ සල්ලි වලින් ගත්තොත් රුපියල් 5000ක් දෙනවා කියන එක 4830ක් විතර දෙනවා කියන එක තමයි අපි එකෙන් අදහස් වෙන්නේ. ඒක අපි verbal contract එකක්. නමුත් ඒක අපි lump sum contract. නමුත් අපි මේ වෙලාවේදී කියන්නේ නැහැ වාහනේ භාගයට හේදුවා කියලා ඔයාට අපි ගාණක් අඩු කරන්නේ නැහැ. වාහනේ හොඳට හේදුවා කියලා තවදුරටත් අපි ගාණ වැඩි කරන්නේත් නැහැ. ඔන්න ඔය කියන concept එක තමයි අපි lump sum contract එකෙන් කරන්නේ. ඒකෙන් අපි deliver කරන්නේ මොකද්ද? employer ට price certainty කියන එක මම මගේ pocket එකේ වියදම් කරන්නේ මේකයි කියන එක පිළිබඳ assurance එකක්. අපි දෙන එක තමයි ඒ basic idea එක. හරි? ඒක තමයි ඒක කරන්න පුළුවන් විවිධාකාර විදි තියෙනවා. එතනදී එන ප්‍රශ්න ගොඩක් තියෙනවා. ඒව ගැන අපි ඉදිරියට කතා කරනවා. right? ඊළඟට අපි යනවා lump sum contract එක තියෙන advantages. Now we are going to talk about the pros and cons of lump sum contracts, right? So pros means the advantages, cons means the disadvantages. I specifically use these colors, green and red. Red means stop, right? Green means go ahead. So if you are seeing something is of advantage to you, you go ahead. If you feel that something is not advantageous to you, you don't go ahead, right? Now, the importance of understanding pros and cons is that you foresee if there is any sort of a risk by adapting a lump sum contract, that you can avoid it in advance, right? Now, I will tell you a little bit of examples when I'm going through this particular elements. So, when you are talking about a lump sum contract, it is a simple. There it is in for the simplicity. Now, if you take into account the FIDIC yellow book, design and build, right? It is essentially a lump sum contract, right? The contractor designs and the contractor constructs, and it is quite straightforward. The employer doesn't have to go through the hassle of worrying about the design responsibilities and design errors and all these things. However, there are certain provisions in the contract wherein if it goes wrong, that the person who is supervising can go back into track. But in terms of simplicity, it is very compared to the others, it is simple, right? Profitability. Now, when you're talking about profitability, I'm talking about from the point of the employer. Okay. Now, and from the contractor as well, it is also there because it is two sides of the coin. Now, as far as the employer's profitability is concerned, right, he has a finished product for a particular amount of money, and he knows, he is certain at the time of signing the contract, it will be adjusted in a very, very simple way. It will be adjusted very little, but however, he is within the margin. Okay, so budget overrun is not an inherent feature of a lump sum contract. Now, from the profitability of the contract, contractor knows, right, even though there is a risk in the measurements, right, contractor knows what exactly is he getting at the end of the project, right? So this is where the two sides of the coins comes into play as far as the pros of the lump sum contracts are concerned. Then easy financing and cash flow, right? Easy financing and cash flow means, right, in a lump sum contract that you don't have to always change because there are very less number of variations. I'll tell you the reason why it is coming like that, because of the inherent features of the lump sum contract, which says that the design has to be very robust, right? The design has to be complete in order to have a lump sum contract. Otherwise, the contractors are reluctant to price this one. Okay, and then straightforward paperwork, right? This is also one of the advantages of a lump sum contract. We may not be having a lot of disputes because the quantity calculation, quantity measurement problems are very less. So if you see as a simple example, the uh, variation, okay, so the valuation, the monthly valuation will be more succinct, right? The monthly valuation will be a very small type of a work, because it's a sort of a milestone type of payments that you're going to do, right? But as far as the disadvantages are concerned, even though the contractor assures his profitability, he knows that there is a price risk. uh, it is not only the price risk, it is affiliated with the productivity of the contractor's personnel as well, right? Which I will explain within the example that I am going to cite related to the cost value reconciliation, right? So contractor is at a certain type of a risk, but the employer is not at a risk, because employer knows, even though there are certain errors in the BOQ, if things go wrong, even though things go wrong, if the design is robust, okay, some of them have to get some qualifications in order to justify the cons, right? But the contractor is at a certain portion of a risk. Then it is complicated in variations, right? In a lump sum contract, unlike a remeasurement type of a contract or sort of or cost reimbursable type of a contract or maybe a management contract, the complications in variations arise because sometimes there are a lot of disagreement pertaining to the practical aspects of, okay. That is why whenever a variation is being issued, they have to go through certain uh, tedious processes, which I will be explaining in the forthcoming hours, right? And then disastrous if the design is not robust. Now, this is one of the fundamental disadvantages of a lump sum contract. We think this is one of the foundations, right? It is like the four wheels of a car, right? So if one of the wheels is broken, but we say at the time of testing, the car has got very nice four wheels. If the design is not robust, one of the wheels will be broken and it will be um, subjected to lot of disasters. So we are saying the design is perfect. Because of that only the contractor is pricing to a complete set of drawings and specification. But at the end of the day, design is not robust. We may have to put the whole of the design into the dustbin, right? And then it will become a disaster in the lump sum type of a contract. හරි දැන් අපි lump sum contract එකක තියෙන වාසි සහ අවාසි ගැන කතා කරොත් එහෙම fundamentally අපිට කියන්න තියෙනවා වාසි හතරක් ගැන simplicity එහෙමත් නැත්නම් ඒක බොහොම සරලයි lump sum contract එකකදී අපි variations valuations කරන විදිය අපිට ලේසි ඊට අමතරව contract එකේ තියෙන content වලට price agreements කරද්දී අපිට ලේසි වෙනවා ඊට අමතරව profitability පැත්තෙන් ගත්තොත් profitability වල අපි හැමතිස්සෙම කාසියක දෙපැත්තක් වගේ අපි දන්නවා මේක අපි agree වෙනවා එක්තරා ප්‍රමාණයකට ඒ ප්‍රමාණය වෙනස් වීමට තියෙන හැකියාව ගොඩක් අඩුයි remeasurement contract එක හෝ cost reimbursable contract එකක් ගත්තොත් ඕකේ තියෙන්නේ සම්පූර්ණ අනිත් පැත්ත cost reimbursable contract එකකදී contract එකේ risk එක ගොඩක් අඩුයි මොකද contract එකට තමා කරන වැඩවලට තමයි ගෙවන්නේ right for an agreed amount of profit and overheads and all these things හරි එතකොට ඔන්න ඔය කියන profitability කියන එක employee එක පැත්තෙන් ගත්තොත් එහෙම ensure වෙනවා ඊට අමතරව මේ cash flow කියන එක ගොඩක් straight forward අපිට කොටසින් කොටස වෙනස් කරන්න අවශ්‍ය නැහැ මොකද contract sum එක එහෙමත් නැත්නම් අපි contract price එක කියලා කියනවා FIDIC version එකේදී එච්චර වෙනස් වෙන්නේ නැති නිසා paperwork ගොඩක් අඩු වෙනවා straight forward simplify ඔයගොල්ලෝ variation නැත්නම් valuation නැත්නම් තේරෙනවා ඒකදී ලොකු paperwork එකක් දෙන්න අවශ්‍ය නැහැ remeasurements ඒ ගැන කතා කරන්න හරි එතකොට නමුත් contract එකට ලොකු risk එකක් තියෙනවා ඒ risk එක contract එකේ price එක විතරක්ම නෙවෙයි contract හොඳටම දන්නවා මේ අපි golden rule එකක් අපි මේක ගැන කතා කරනවා ඉස්සරහට යද්දී BOQ quantities are never used for payment purposes in lump sum contracts මේක අපි golden rule එකක් හැටියට තමයි සලකන්නේ lump sum contracts වල එතකොට මෙතනදී මේ contractor තියෙන risk එක එයාගේ cost එක විතරක් නෙවෙයි productivity out ගියොත් එහෙම ඒක substantially වෙනස් වෙන්න පුළුවන් payment එක කරද්දී ඊට අමතරව මේ variations ගැන කතා කරද්දී අපි lump sum contract එකකදී අපි බලාපොරොත්තු වෙන්නේ නැහැ ලොකු variations ඒ නිසාම මේ variation කරන්න යද්දී අපිට ලොකු ප්‍රශ්න ඇති වෙනවා price එක agree වෙන්න යද්දී ඒ වගේ දේවල් අපි මෙතනදී කතා කරනවා ඊට අමතරව design එක හරියටම නැත්තම් අපි කියනවා lump sum contract එකකදී design එක හොඳ නිසා තමයි අපි lump sum contract එකට යන්නේ කියලා නමුත් design එක හරියට නැත්තම් ඒක ලොකු disaster එකක් වෙනවා. හැබැයි මේක බලපාන්නේ නැහැ plant design and build yellow book එකකට. මොකද ඒකේ design responsibility එක contractor තියෙන නිසා. Right. Are there any other contracts other than lump sum contracts? Okay. I told two words. One is called procurement and the methodology. Okay, now there are certain questions which have been asked. I'll be taking all these questions into account and I'll be answering in the question and answer session within the second session, okay? Because within 2 hours time, I'm going to finish certain things. I have allotted a time period of more than 30 minutes in the next session in order to answer all your questions. It's good that you ask these questions right now, okay? And then I'm going to take into account all these questions, and then based on that, I will be answering very comprehensively after this one, right? Even though I call them lump sum, right? There is something called remeasurement contracts. There is something called target sum contracts. There is something called guaranteed maximum price contracts, cost reimbursable contracts, and management contracts, right? So you need to benchmark a lump sum contract with these types of contracts in order for you to identify what are the advantages and disadvantages, and where does lump sum contract stand with these separate types of contracts, and what is the usage of that, right? In order to achieve that one, right, I have done some comparisons between lump sum contract, right? The first one is lump sum versus remeasurement. This is a very common thing, right? Before coming into this one, I just wanted to highlight the FIDIC, JCT, the Joint Contractors Tribunal has issued three types of contracts in 2016. Now, the most recent ones that you may have within you may be 2011. It is like FIDIC 99 and FIDIC 2017, right? Now, JCT has got three types of standard forms. One is called standard building. Don't get misunderstood by this statement. It is not only. It is only for the type of traditional contracts. Okay, design and build is there. Cost reimbursable is there. Management contracts are there. JCT has got a wide range of standard forms of contract. Now I am going to confine my discussion in order to for you to identify what a lump sum contract means in this regard, right? Standard bidding contract without quantities is there. Standard bidding contract with quantities is there. This is why when you go a few slides up, the RICS has defined this as the fixed price. See the mouse which is moving. The fixed price is usually arrived at through the computation of a bill of quantities or activity schedule. Okay. So activity schedule and bill of quantities are two different things which we will be discussing separately, right? So then the JCT accommodates these two requirements within standard building contract with quantities and standard building contract without quantities, right? Um, then there is a separate standard form of contract issued by JCT called standard building contract with approximate quantities. This is something very similar to the remeasurement type of a contract which you encounter in the FIDIC, right? Now, let us understand what exactly is the comparison between a lump sum contract and a remeasurement type of a contract, right? There's another message. Let me just go through that one. You were talking about a golden rule of lump sum. Can you please mention the source for that? Did you cite based on the hierarchy of documents? Okay, now there are some other questions as well. I'll be taking all of them into account, right? Lump sum versus remeasurement. The remeasurement contract, it says where work cannot be adequately quantified at the time of tender. Okay, a remeasurement type of a contract is a work cannot be adequately quantified either at the time of tender. Then a schedule of rates or estimated, approximate, or provisional quantity arrangements. Now, these words are coming into play. Now, for example, if we are using Oman standard form of contract, we call it estimated quantities, clause 55. If you are using JCT, we call them approximate, right? And in Oman conditions of contract, maybe in Sri Lanka also, we are using provisional quantity arrangements. Now, in this part of the world, in Oman conditions of contract, we have got something called clause 55, estimated quantities, clause 56, actual and correct quantities. But in a BOQ, which has been designed based on clause 56, also there is an element of remeasurement, which is called, within brackets, we put them as provisional. So all these words are appearing across different ranges of standard forms of contract. Okay. Then a schedule of rates is also coming into play, where work cannot be adequately quantified at the time of tender. Now, for example, let's say in a particular contract, uh, you don't have rock excavation. You do not talk about rock excavation. However, in a schedule of rates, you put a amount for the rock excavation in this particular site, even though the soil investigation does not support the notion that the rock is there. There is a schedule of rate which is allowing the contractor to put a rate for that one. So it becomes a remeasurement area, right? The contracting organization is paid for the actual quantities of work undertaken, right? It should be noted that lump sum and target sum contracts. Now, we are talking about target sum contracts. I will be talking about that once we go on, right? Um, also can also include provisions for remeasurement if elements of the work cannot be accurately or fairly measured at the time of tender. So I'm going to talk about that separately. However, the basic difference between a lump sum contract is lump sum contract we call is the fixed price, where the BOQ quantities are not remeasured for valuation purposes. But in the remeasurement type of a contract, the BOQ quantities are remeasured for purposes, right? Then we will move on to the next item, which is called the target sum. Okay. Target sum contract is somewhat similar to guaranteed maximum price type of a contract, but the target will usually be built up in a similar way to a calculation of a fixed price in a lump sum contract. Okay. The final target, including contractual variations, will then be compared with actual costs incurred by the contracting organization. Now, the most important thing, the difference, right? Both overspend and savings, usually known as pain and gain in a target sum type of a contract, right? We are having a ceiling. Okay, we say we will finish this particular project by this particular amount, right? But if there is any sort of a saving, there will be a incentive. If there is any sort of a overspend, there will be a penalty. But it will be split between the client and the contractor. So this encourages collaborative approach, because both parties know, right? Both parties know if something is overspent than agreed, he will be suffering. He or she will be suffering from the penalties. If both parties know that we can achieve savings, he or she will be happy, right? So this is somewhat similar to the mechanism which has been adopted by FIDIC for the value engineering proposals, especially the gain purpose, not the pain, right? Value engineering clause, which is appearing from FIDIC 1999 version onwards, specially speaks about this particular saving, right? So this is also important, right? Now, lump sum versus GMP. Now it is like this. Now, in Sri Lanka that we got the police, right? If you are talking about the police in Sri Lanka, there is a special unit in police called Special Task Force, STF, right? So GMP is something like STF. It is also the police, but is a special task force, right? So GMP type of a contract, it is very similar to target sum, but with a contractual guaranteed maximum price agreed in the contract, right? The difference between that is, uh, in the previous one, guaranteed maximum price is not a contractual obligation. Okay. Here it says GMP can also exist as a variant to lump sum agreement with limited opportunities for the lump sum to be increased for change. The contractor will not be entitled to any additional money should the GMP be exceeded. Okay. Unless this is due for the contractual variation. Okay. The opportunities for which will often be much lower than for any of the alternatives above. I'm talking about the previous alternatives, right? Then there is a type called the cost reimbursable contracts. It is not reimbursable, it is reimbursable, right? So sometimes I also may pronounce it in a different way, but it is the correct wording is cost reimbursable, right? where the contracting organization is paid the actual costs incurred in the delivering the contract plus an agreed profit fee. They call it the profit fee. Actually, because the overheads also will be included within the amounts which will be given by the cost reimbursable basis, right? Because overheads may be changing, right? However, there is a profit, the agreed profit between the parties whenever there is an additional work or everything will be done based on the cost reimbursable basis. And there is a special provision in NEC, new engineering contract, related to that as well, right? So it is there, right? And there is another part called lump sum versus management. Uh, okay, now there is another question. Can you explain FIDIC provision in lump sum contract? If there are saving due to the value engineering, how the savings will be shared or total will go to the contractor? Oh, it's a very nice, good question. Definitely, I'll be addressing this issue. Thank you so much for that question, right? It is that particular gentleman, that delegate asks about the clause 13.2, the value engineering clause. How the value engineering clause will be changing with the lump sum contract, and I will address that as well, right? Now the management. Now why I spoke about the management here is, when you talk about a general context, forget about all the standard forms of contract. When you talk about general context, we have got three types of procurement. One is traditional, two is design and build, three is management. Okay. Now, that is why I told this is a procurement method. Okay. Management type is a procurement method. Where a contracting organization or sometimes a consultancy is paid to manage the delivery of a project. Why they say a contracting organization or sometimes consultancy? You can see management type of procurement has got two different types. Basically, majorly two different types. That is called management contracting and construction management. Okay. So those are two different types of things, right? Where in the construction management, the client appoints a separate construction manager to manage the project, but retains the contractual link, right? But in management contracting, the client is dealing with the management contractor and the contractual link is with the separate contractor. So that is why it says it may be a contracting organization or sometimes a consultancy, is paid to manage the delivery of the project through the engagement of a series of trade contractors, either a percentage fee, a fixed fee, or time charge fee. Now, that is why I am saying a management type of a procurement has got the inherent features of both lump sum and remeasurement. Okay, it can be a percentage, a fixed fee, or a time charge fee. Now I am going up in order to just recap what I have told you, right? Then අපි lump sum contract සමග ළඟින් යන, එහෙමත් නැත්නම් lump sum contracts තියෙන වපසරියේම තියෙන අනිත් contract types ගැන කතා කරනකොට අපේ ඔළුවට එනවා contract වර්ග කීපයක් ගැන. එකක් තමයි remeasurement contract කියන්නේ. එතකොට remeasurement contract කියන එක අපි යම් විවිධ වචන භාවිත කරනවා. JCT type of contract එකදී අපි කියන්නේ approximate bill of quantities කියලා. එතකොට FIDIC version එකේදී අපි කියන්නේ remeasurement කියලා, right? එතකොට අපි ඊට අමතරව තව එක જાතියෙම දෙකක් තියෙනවා, target sum contracts සහ guaranteed maximum price contracts කියලා. එතකොට ඒකෙදී අපි හැසිරෙන ආකාරය, ඒකේ මෙකැනිසම් එක lump sum contract එකකට වඩා යම් වෙනසක් තියෙනවා. ඒ වෙනස දැන් අපි target sum එක guaranteed maximum price එක අපි නියතයක් වුණාට එතනින් උඩට යද්දි ඒ saving එක ඒ අපි ලබා ගන්න saving එක අපි බෙදා ගන්නවා. එතනින් යටට යද්දි saving එක අපි බෙදා ගන්නවා. එතනින් උඩට යද්දි අපි ඒ අලාභයත් විඳ ගන්නවා. නමුත් lump sum contract එකකදී අපි ඒ වගේ mechanism එකක් නැහැ. නමුත් අරකින් guaranteed maximum price contract එකක් වගේ contract එකක් අපි භාවිත කරාම ඕනම කෙනෙක්ගේ ඔළුවට යනවා, right, මම මේ වැරද්ද කරොත් මට මේක විඳින්න වෙනවා කියන එක. ඒක නිකන් අපි වාහනයකින් අපි යනකොට අපි ඕවර් ස්පීඩ් කරනකොට අපි punishment එකක් දෙනවා වගේ වැඩක්. right? එතකොට මේ නමුත් lump sum contract එකකදී අපි time related penalty එකක් ගැන කතා කරාට ඔය කියන cost related penalty එකක් ගැන කතා කරන්නේ නැහැ. අන්න ඒ වෙනස අපි හඳුනාගත යුතුයි. right? ඒක තමයි ඔය target sum contracts සහ guaranteed maximum price contracts අතර සහ lump sum අතර තියෙන වෙනස. එතකොට cost reimbursable contract කියන්නේ සම්පූර්ණයෙන්ම වෙනස් ආරක මෙකැනිසම් එකක්. එතනදී අපි employer එහෙමත් නැත්නම් client අපි ගන්නවා risk එක අර cost එකේ තියෙන market fluctuations ඒ සියල්ලම risk එක client ගන්නවා. නමුත් එතනදී contractor ඊටමත් සුබදායි ආරංචියක් තියෙන්නේ. මොකද contractor අද වෙලද පොළට ගිහිල්ලා සිමෙන්ති කොටයක් ගන්න කිසියම් මුදලක් වැය කරනවා නම් ඊට මාසයකට පස්සේ ගිහිල්ලා සිමෙන්ති කොටයක් ගන්න වැය කරන මුදල ඊට වැඩිය වැඩි නම් contractorට අර කියන වෙනස ලැබෙනවා. ඒක ගොඩක් ළඟින් යනවා අර quantum merit කියන principle එකත් එක්ක. ඒකේ ඔය කියන risk එක ගොඩක් වෙලාවට අඩුයි. නමුත් management type contract කියන එක සම්පූර්ණයෙන්ම ඒක procurement type එකක් ගැනයි අපි මේ කතා කරන්නේ. නමුත් මේ management type contract එකේ තියෙන වැදගත්කම තියෙන්නේ ඒකේ තියෙනවා අර mix එකක්, blend එකක් තියෙනවා. lump sum contract වගේ fixed price එකක් අපිට agree වෙන්නත් පුළුවන්. එහෙමත් නැත්නම් percentage එකක් අපිට agree වෙන්න පුළුවන්. එහෙම නැත්නම් rate එකක් agree වෙන්න පුළුවන්. ඒ ඔක්කොගෙම තියෙන mix එකක් ගැන තමයි මේ කතා කරන්නේ. ඒතර මේ ටික අපි ඔක්කොම අපි හොඳට මේ සුසංයෝගය හොඳට බැලුවොත් lump sum contract සහ අනිත් contracts අතර තියෙන වෙනස්කම් අපි හඳුනාගත යුතුයි. lump sum contract එක කියන එක හරියට refine කරගන්න. ඒක නිකන් හරියට අපි එක්තරා පුද්ගලයන් කීප දෙනෙක් ඉන්නවා. ඒ පුද්ගලයන් කීප දෙනා අපි හිතමු රග්බි ක්‍රීඩකයෝ කියලා. ඒ රග්බි සෙල්ලම් කරන අවස්ථාවේදී එක එක තැන්වල තියෙන වැදගත්කම මත ඒ රග්බි ක්‍රීඩකයන් තැන්වල ප්ලේස් කරනවා. අන්න ඒ වගේ තමයි lump sum contract එකක් අවශ්‍ය වෙන්නේ මොන අවස්ථාවේද? අපි ෆුට්බෝල් ගත්තොත් ෆුට්බෝල් වල ගෝලි ළඟින් ඉන්න ක්‍රීඩකයා මොකද්ද කරන්නේ? එයා ගෝලිට බැරි වුණොත් එහෙම අර බෝලේ නැවතත් අරගෙන අනිත් පැත්තට දුවන්න බලාගෙන ඉන්න පුද්ගලෙක්. නමුත් ඕගොල්ලන්ට ඇතුළතදී පේනවා මැදදී මේ ක්‍රීඩකයන් එහාට මෙහාට හයියෙන් දුවන ක්‍රීඩකයන් සෙට් එකක් ඉන්නවා. එතකොට අන්න lump sum contract එක කියන එක කොතනටද හරියටම අදාළ වෙන්නේ කියන එක තේරුම් ගැනීම සඳහා අනිත් contracts ගැනත් අපි යම් අවබෝධයක් ලබා ගත යුතුයි. ඒක තමයි අපි මෙතනදී කරේ. Right. Now we are going back to this lump sum contract. Now we are going into the core. Now we have got the background knowledge. We spoke about the definitions and we are going to talk about the lump sum contract now. Features of a lump sum contract. Now I can lump them up into 5 basic categories. Now previously we were talking about the pros and cons, that is advantages and disadvantages. Now here we are going to talk about agreement of a single lump sum of money between the parties to the contract before the works begin. That is one of the inherent features of a lump sum contract. Right? Now, for example, cost reimbursable contract is totally different from this concept. There is no single lump sum of money agreement between the parties to the contract. Now, the project is well defined. Now, once again, that wheel example. You are saying the car is good. All the 4 wheels are good. But is that particular wheel is not good, you will fail. That is why I am saying I use the word disastrous. I use the special word disastrous if the project is not well defined. Okay. So in a lump sum contract, in order to become a lump sum contract, it has to be a well defined project. Number 2, significant changes are unlikely. This is where we don't have provisional sums. Okay. We don't have uncertainties. We don't have remeasurements. That is why the significant changes are unlikely in the context of a lump sum contract. Cost certainty to the client, that I have discussed with you, and quantity risk is with the contractor. It is not only the quantity, there is a productivity risk as well. So accumulated and associated sort of risk, which we are going to discuss separately. Right? Now, FIDIC Red Book 2017 version, right? This particular document has now gone through a lot of reviews, okay, a lot of insights and a lot of lessons learned. Especially, they were comparing that along with FIDIC 1999 version. Now we are slowly stepping into what do we have to do? Now we are focusing. It is like a torch. Now we have got a parabolic place in the torch. Now in the torch, without that particular parabolic element, you cannot focus the light, right? When you are not focusing the light, we were talking about remeasurement contracts, we were talking about management contracts, cost reimbursable. Now we are going to focus on this particular area with the knowledge of the periphery, right? That is what we are going to do, right? Can a lump sum contract be subjected to price change under FIDIC credit book? Now this question needs to be answered, right? Now I will leave this particular question to you, right? Within a day's time, you can answer to me for this question. I will come up with the answer with the next session, because then you will go through them, you will understand. If you get the most suitable answer which will be given by the person, will get an opportunity for a free seminar for the next year, right? So the question is, can a lump sum contract be subjected to price change under FIDIC credit book, right? For the purpose of your understanding, last time also I did the same thing. I will just put my WhatsApp number here, so that you can WhatsApp me the answer. Okay, right. 00968 for the Oman country code, right? So the question to be answered is, can a lump sum contract be subjected to price change under FIDIC credit book? Okay, so now you have to answer this particular question in the most appropriate way, right? Let's see who is going to give a most suitable answer, right? Uh, there is there are two different defined terms called variation and claim in FIDIC credit book 2017 version. But in the previous version of the FIDIC, right, the word claim was not a defined term, right? Now both the variation and claim has become a defined term. Why I put this thing is especially is in order for you to understand what is the answer to this question. Now, a variation means any change to the works which is instructed as a variation under clause 30. Now, this is somewhat different from the compensation events which is appearing within the NEC contract, or relevant event which is appearing within the JCT type of a contract. Okay, so the word variation has been specifically used in FIDIC credit book in order to identify any change to the works which is instructed as a variation under clause 13. So it talks about clause 13, the clause, not the sub clauses. Okay, number two, not only the sub clauses. Number two, claim means a request or assertion by one party to the other party for an entitlement or relief under any clause of these conditions. These conditions means the standard form of conditions. Now, the definition of a claim has got two particular aspects. Number one is an entitlement. Number two is a relief. Okay, so the entitlement and relief are two different things. Now, for example, if you are talking about a particular standard form of a contract, right, a standard specification, suppose that you have used the BS code as well as the Euro code. Okay, now you know BS 8110 is specifically related to the structural design. Likewise, the EN2, that European guideline 2, European context, is also related to the structural design, right? Now, if you mix up the European guideline and the BS code within the same specification, now the order of priority will not come into play. So that is why I eliminated that ambiguity, because you know at the time of pricing, the FIDIC newer version is talking about the priority of the documents, wherein specification comes above the drawings. Okay. Now, within the same specification, that means you have the same grounds for argument, right? In one occasion, they talk about BS 8110. In another occasion, they talk about EN2, right? Suppose that the European code gives more stringent requirement than the BS code, but in the drawings and in the as per the law of the country, okay, you are supposed to go as per the BS codes. Now, suppose the Muscat municipality in terms of Oman, right? Muscat municipality says that the structural design has to be done by BS code. Let's say, okay. Now in Sri Lanka, you will say that in Sri Lankan, whatever the Sri Lankan authority will say that it has to be the BS code. So the engineer has erroneously inserted a Euro code, right, which is more stringent, which is more pricey price. Therefore, the contractor can have a relief. Okay, the contractor can have a relief saying this is not appropriate. Okay, therefore there is a claim for relief. I am not going to design for and I am not going to perform the execution of the works for a EN code, sorry, European code, right? Right. Likewise, that is a relief. But as far as the entitlement is concerned, right, the contractor might have seen some ambiguity, right? But as per the priority of the documents, he has priced the specification, but the drawings has got more details. The contractor can say, I priced in accordance with the order of priority, right? And therefore, this particular aspect of the drawing has not been taken into account by me. So there is an argument for entitlement. Not all the cases will win like that. But anyway, there is an argument. So that is the difference between an entitlement and a relief. So this is why I wanted to tell that. Then I mentioned about a golden principle, and then that there was a question from one particular gentleman whether I have taken a golden principle. You were talking about a golden rule of a lump sum contract. Can you please mention the source for that? Did you cite it based on the hierarchy of documents? I meant drawing specification on FIDIC. So it's a very nice question, and I will answer to that question as well, right? FIDIC Golden Principles were issued in 2019. It was the first edition. This is the freely available set of guidelines given by FIDIC. Now, we all know in the UK context, there is something called an act called Unfair Terms Act, which was issued in 1977. I was 1 year old when this was issued, right? So, Unfair Terms Act in UK has given certain guidelines for the drafters of a contract that you should not be putting certain unfair things. Now, for example, we call it pay when paid. In our terminology, we call it back-to-back payment, right? The contractor will be paying for the subcontractor, only he was paid by the employer. So the poor subcontractor will suffer because of another person's error. Now, Housing Grants and Regeneration Act 1996, which was issued in UK, has forbidden, has restricted that particular privilege. Even 1977 version has given some guideline related to that one. If the pay when paid clause is applied, it is prohibited by the law, right? So likewise, when the standard form of contract has been drafted. Now, why I am talking about that one? Now I am creating the groundwork for you to prepare the standard conditions of contract with particular conditions, with special provisions. Now, in the FIDIC terminology, they don't call it the particular conditions anymore. They call it special provisions. Special provision has got two. Number one is for the contract data, special provision A. Special provision B is for the so-called particular conditions of contract. Now, FIDIC Golden Principle has been drafted in such a way, right? Even though the employers can do bespoke conditions of contract. Now, for example, changing a remeasurement contract to a lump sum contract. Okay. In the JCT format, you don't have to do that one because there is a separate contract for that. In NEC type of contract, cost reimbursable is separately mentioned, like that it is there, right? So, however, in the FIDIC version, if you are going to change that particular red book to a lump sum contract, there are guidelines which is given by the FIDIC. However, apart from the guidelines, there may be certain changes which is being implemented by certain employers or rather the engineers. So, in order to prohibit that exercising unauthorized or exercising undue advantage, there is a golden principle, set of golden principles, which is issued by the FIDIC. This is there within FIDIC 2017 Red Book itself. Okay, if you go to the special provisions, it is there. It says FIDIC strongly recommends. It does not just confine to the verb recommends. It has got an adverb, strongly recommends, that the employer, the contractor, and all drafters of the special provisions. He is talking about the legal people as well. Okay, so the drafters of the special provisions may not be the employer. It may be a person, a specialist who has been contracted by the employer. Take all due regards to the 5 FIDIC golden principles. Right? Number 1, the duties, rights, obligations, roles, and responsibilities of all the contract participants must be generally as implied in the general conditions. The duties, rights, obligations, roles, and responsibilities. Okay, and appropriate to the requirement of the project. Okay, now you cannot ask the contractor to talk about an unnecessary level of environmental control of a project, right? If you are doing something like a particular construction in a desert. Okay, now if you are talking about dust accumulation, right? Dust accumulation can be controlled in a location where there are a lot of residents, where there are people who will be affected. But in a desert, if there are no animals, I'm not talking about just the people, right? Even though there are no animals, there is no point in doing a control in dust accumulation for the residents, right? I'm not talking about the construction people. Definitely for the construction people, you have to do that one. I'm talking about the people in the periphery, right? The special provisions might not have been drafted for that one. Number 2, the particular conditions must be drafted clearly and unambiguously. Now, this is of utmost importance, right? Now, if you are now FIDIC Red Book 2017 has got 21 clauses and hundreds of sub clauses. If you change any word in a particular subclause or a clause, right, you have to see the repercussions. You have to see the consequences where that particular term or the related terms are being parked, how it will be changed. Now, this give you a very nice example when we move on to the changing of this particular drafting of this Red Book contract. Okay, then you will understand how exactly it will address the issue which I am talking about. The particular conditions must be drafted clearly and unambiguously. Now, suppose you leave a particular part of the remeasurement, okay, within the standard form of contract, and then you put it as a lump sum contract. That is called an ambiguity. Okay, isn't it? Maybe it is a discrepancy. So it has to be drafted clearly and unambiguously. Golden rule 3, the particular conditions must not change the balance of risk reward allocation provided for general conditions. Once again, it is talking about the first golden principle is talking about duties, rights, obligations, roles, and responsibilities. The third golden principle is talk about the risk. As we all know, the risk allocation has been now, if you see a lot of new reviews which has been done related to the particular FIDIC 2017 version Red Book, it suggested that there is a more balance now between the risks. So that allocation should not be violated. That is what it is always saying. Now, if you are talking about the notion of lump sum contract, the notion itself transfers the risk of the quantities to the contractor, isn't it? Right? But it is a notion, right? It is a notion which has been invented and drafted and indicated within the FIDIC Red Book as the guideline. So it is not that we are reinventing the wheel. Therefore, the type of contract in the type of procurement, the type of contract has been changed, it does not fall into this particular category, right? All the particular conditions must not change the balance of risk reward allocation provided for in general conditions. This is what it says, right? The clauses have been carefully drafted. The amended clauses for the lump sum contract has been very carefully drafted. Then you will let I will let you know once we go through that one, right? And then all time periods specified in the contract for contract participants to perform their obligations must be reasonable durations, right? This is what we call as a common law principle called within reasonable time. Now, for example, there are a lot of common law principles which we encounter in our lives. Fit for purpose, within reasonable time, those are the things that we normally come across as the common law principles. So within reasonable time is of utmost importance. Now, if you see this particular FIDIC Red Book 2017 version, the clause, I think 13.1, right? 13.1, no, 8.1. 8.1 is related to the commencement of the works. Okay. The commencement of the work 18.1 says, right, within the after issue of the letter of acceptance, within 42 days the contractor has to commence the works, right? And there are certain time periods which is stipulated by looking at the reasonability. Now, for example, the base date which is indicated within the FIDIC Red Book is 28 days before the submission of the tender submission. Why we put it like that? If there is a legislation change between those 20 to 8 days, the contractor should not be bothered about that, because he clearly draws a line. This is the date for me to price, because within those 28 days he is very busy with pricing the document, compiling the things, getting quotations from the subcontractors. All these things are there. So if something happens between that particular base date and the submission date of the tender, it is considered as something which has happened after signing of the contract. So that is very important. All time periods specified in the contract for a contract participants to perform their obligations must be a reasonable duration. So number 5, all formal disputes must be referred to dispute avoidance and adjudication board for a provisionally binding decision as condition precedent to arbitration. Now, it says dispute adjudication and avoidance board. However, the FIDIC 99 users are knowing about that most of the time, that we avoid the extra fee that is being paid to the dispute adjudication board, and we allow the engineer to do the same. So these sort of things are happening, right? So in the special provisions, they change that one. These FIDIC golden principles are described and explained in the publication FIDIC's Golden Principle. This is available within this particular, this about 50-page document. Go and read it. It is very good. Ethical, the type of document where you can practice your ethics into this one, right? So this is all about the FIDIC Golden Principle, right? Right. Now, regarding the golden rule that someone asked me about the source of it, right? I will give the exact source. It is actually based on some RICS documents which I have referred. I will give the exact source within next week, right? But normally it is says the BOQ quantities are never remeasured for the purpose of a payment in a lump sum contract. Okay. I'll give you the exact source for that one. And thank you for highlighting that as well, because it is not a golden rule which is appearing within FIDIC conditions of contract, right? Then this is the example that I wanted to talk about, which says the cost value reconciliation exercise for a remeasurement and a lump sum contract. You need to understand this one, because this is one of the part and parcel of a practicing quantity surveyor, especially in construction. Now, suppose you are a contractor's quantity surveyor who is doing a monthly cost value reconciliation. So, in order for you to assist, in order to for you to comprehend what is the difference between a remeasurement type of a contract and a lump sum contract, I have uh, given one example. I will explain it to you right now. Right now, what you are seeing here is okay, and extract from NRM2. But for the benefit of the people who are listening, for the maybe who may not have who may not have exercised a cost value reconciliation, I'll give you a small insight about what cost value reconciliation is, right? Cost value reconciliation is an exercise which is being done in after signing the contract in order to compare the amount of money paid from your pocket and the amount of money that you receive into your pocket. It's like your salary and your expense, right? So at the end of each month, you are getting a salary into your bank account, right? But unless you have a credit card or any other mode of sources, income sources, right? Your main source of payment is that particular salary that you receive, isn't it? So likewise, you are not going to take any money from another project. Contractors do that, but I am saying in a theoretical context, because we need to talk about this particular, we need to ring fence this particular project and identify whether this particular project is profitable or not. Now, in order to have that particular insight, one of the tools which has been used is cost value reconciliation. There are other types of tools such as cost to complete, earn value management, which will serve different purposes. But today, I'm going to confine my discussion about cost value reconciliation. So it is like a cost value reconciliation gives you two benefits, right? Number one is to alarm your tendering department if you are a contractor. Number one is to alarm your tendering department, Mr. Estimator, your rate for this particular item is wrong. Number two is to alarm the project manager, saying, Mr. Project Manager, your people are not working productively. So let me just explain that to you, then you will understand exactly what is the significance of that part. Suppose that you are doing a piling work, okay? Suppose that you are doing a piling work in an enabling works contract in a particular site, right? Now, when you go through the rate breakdown, some of the contractors are reluctant to give the rate breakdowns. There is fairness to that to a certain extent. Sometimes when somebody is asking about a labor rate, okay, if you ask for a material, plant material and labor differently, it's a separate issue. But if somebody is asking from a contractor how much you spend for your um, unskilled labor, sometimes it is a trade secret, okay. Somebody goes into the extent, how did you develop that particular rate, okay. So that is a trade secret, because otherwise if somebody gets to know about this particular rate, right, uh, they can misuse it for another purpose, okay. So however, I'm not going to talk about that now. However, if you are within a contracting organization, and if you are doing a cost value reconciliation, let's say you have a particular rate for the piling works. That particular rate has got the machinery rate, labor rate, because there are certain banksmen who needs to be there, machine operators needs to be there, and material rate, something like bentonite. You might have heard of bentonite, right? Which is being used for this core drilling, right? In order to have that particular stability, right? So when you are doing that particular exercise, you check that particular rate. Let's say that particular piling rate, you got all the resources. What is required? You get it from the rock bottom. You start from the first principles. This many number of machine hours are required to do 1 meter of piling. This many number of plant operators are required. This many number of bankers are required, and this many number of people. This many number of material, bentonite, these things are required. So you build up that particular rate, right? Then you are doing what is called a work study. Now, one day when I was working in the Russell Hamra development project in BDO, when I went to the site, my project manager asked me, "Did you find the rope?" Okay, so I didn't get the joke. Then he asked, the quantity surveyors, when they go to the site, they don't know how to come back to the site. Okay, so this is how the project managers think about the quantity surveys. So that means the quantity surveyors never go to the site, or they are lost when they go to the site. But it is not in reality. I know our quantity surveyors are very good. They are visiting the site every day and they are doing their job, right? So when you go to the site and then you find you are doing a work study. What is a work study? This I learned from one of the senior engineers in CECB, Central Engineering Consultancy Bureau, for my first project, which was called the Postal Complex Project, a 10-story building, which is next to that Nelum Kuluna in Sri Lanka. The Nelum Kuluna is called the highest or the tallest structure in Sri Lanka, right? So that particular gentleman who was working in CECB, if there are people who are working in CECB, I don't want to mention the name, but that particular person is always having work studies. He's always doing work studies. He observes the works, right? So this particular quantity survey, let's say you are a senior quantity survey, you ask your site quantity survey to go there and check. So he is checking, okay, from the beginning, there's a 9-meter deep excavation which needs to be done, piling needs to be done. So he's marking the time which is required to do that one. How much of diesel has gone? Everything he records, right? And everything he records, and all of a sudden, then he comes back and say, the cost for these particular items, if you go in this particular way, is exceeding what has been allocated within the BOQ. Now you are alarmed. That means you are doing 1 meter deep excavation using piling. You do the piling excavation. For that you are getting this much of money, but you are paying more than that. So that means the cost is more than the value. That means you are running at a loss, right? So what are the two questions which comes into your mind? Number one, whether the estimator has done the estimation based on the correct norms. Number two, whether we are productive, whether the people who are being allocated at the site are productive. So in order to identify that one, you do a similar work study. You ask from the nearest site, another site, or you check the norms, right? And then you find out that the estimator has done a small mistake, right? Instead of 2 machine hours, he has put 1.5 machine hours to do 1 meter deep of excavation. So because of that, the estimation is wrong. So you can give an advice based on your work study that, Mr. Estimator, your estimation is wrong for future tenders, because for this tender you cannot do that change. For future tenders, please alter that from 1.5 hours to 2 hours. So that is the advice that you can give based on a work study. Very important, right? Number two, you find that the people who are working for excavation, let's say it is a manual excavation, he is taking longer hours than which is stipulated. Once again, you are going into the norms, you are checking with other sites, and you find there is nothing wrong in what the estimator has put. He put the correct amount, right? But this particular person is not performing well. So there is a productivity issue. Then you have to advise the project manager, Mr. Project Manager, if you go in this way, we will go at a loss, right? So in order to correct that, either you train these people or put more capable people. So this is how the cost value reconciliation has been done in order to rectify these things, right? If the estimator is wrong, we cannot correct anything. But if the people are poorly productive, you can correct that one. So that is how the cost value reconciliation has been utilized in practice. So I believe that you have got a very good idea about that one, right? Then I'm going into how the cost value reconciliation is being done for the remeasurement versus lump sum. So I have selected this particular section from NRM2, the new rules of measurement. Actually, I accidentally put it as NRM1, but it is NRM2. Right? Let me correct that one. Right? NRM2, it says excavating and filling has got 5 different elements. Site clearance, preparation, excavations, disposal, fillings, and membranes. So I extracted this particular excavation portion appearing within the NRM2. So it says excavation commencing level stated if not original ground level, bulk excavation and foundation excavation. Okay. So then let me go into the normal type of a BOQ that has been prepared based on NRM. So item reference signifies the code of NRM1. right. Then it says the bulk excavation not exceeding 2 meter deep, you have a quantity of 230, rate of 1.5. As for the BOQ, if you expend all these figures, you will end up with 1970 reals. Okay, so this is the agreed value as per the contract, right? Now, when it goes to the remeasurement type of a contract, when you do the cost value reconciliation, as I have explained to you, right? Now I am circling the area where the actual quantity comes into play. Okay, actual quantity comes in. Now once again I am going back to this one. The actual quantity is not there because this is at the time of signing the contract, right? Now when you are executing the work, suppose that you completed this particular part of the work, right? Now the actual quantity has changed because this is a remeasurement contract, right? The rate which is stipulated in the contract, okay, the rate which is stipulated in the contract is of no significance to you when you are assessing the cost. It's not the value, okay? When you are assessing the cost, you do your work study and you understand this is actually less than what is given in the BOQ. This is actually little less than what is given in the BOQ. This is again less, but there is a slight increase in the fourth element for the foundation of excavation over 2 meters, right? And because of that, it triggered an additional cost. However, you are still, you can see in the BOQ, you were expecting 400 reals for this particular element, but because of the change in the quantity and in the change in the rate, you have incurred an additional amount here. Therefore, you can see that there is a saving. Your cost is less than the value, right? And then you go into the lump sum type of a contract, right? When you go to the lump sum contract here, you can understand the actual quantity is of no importance to you because you are not remeasuring the quantities for the payment purposes, right? Therefore, you are expending the quantity which is given in the contract with the actual cost which was incurred, right? And then you will understand, right? Actual rate which has been incurred is 1970, right? But if you are talking about the actual there is something which you need to change here, which I will do right now, which is in this CVR example, right? Instead of this particular quantity, the value, wait, let me just share that particular one. Give me a second. Excel sheet, right? Okay, I hope now you can see this particular Excel sheet, right? In this particular quantity, the for the value cost value reconciliation that you are doing for this lump sum type of a contract, right? Lump sum type of a contract, you are using these particular values, actual quantity, right? Right? Even though actual quantity is of no significance in the contractual figure, you can see that you are using the actual quantity with the actual cost. Then again, you can see the cost is greater than value as opposed to the previous one, right? As opposed to the previous one, the cost is greater than value. So therefore, you can understand that in a lump sum contract, the cost value reconciliation is taking a different stance than a remeasurement contract that you need to understand, right? Again, you come into another example here. Let me stop sharing this one and then start sharing my presentation once again because there's an amendment which needs to be done in the presentation. In anyway, not an issue, right? Let's go into the CVR approach to remeasurement contracts once again, right? Suppose that there is a substantial increase in the quantity of this fourth element, okay? You can see the actual quantity substantially increased into 320, okay? If there is a substantial increase in the quantity, once again, you can see because of that, the cost value reconciliation is going out of the uh, out of the uh, proportion. Therefore, when you are doing a remeasurement versus lump sum contract, you can see, right, both the quantity and the rate will change in the remeasurement type of a contract when you are doing the cost value reconciliation. But when you are doing a lump sum quantity, lump sum thing, again you are doing the same thing, but you are getting paid for what is given in the BOQ only. That is the difference between doing a cost value reconciliation in a remeasurement type of a contract and a lump sum contract. So with this case study, right, I will put the correct figures here, and then when I send the presentation, you will understand. You will get the presentation by tomorrow, right? Then you can compare this and identify sometimes with the same quantities in a remeasurement contract you have got a saving, but in a lump sum contract you are running at a loss. So that is what I wanted to explain. Now we are coming into the amendment part of the FIDIC conditions of contract related to the lump sum contract. There are 4 different clauses which you need to take into account. Okay, what is given within brackets are the clauses, right? Commencement, delays, and suspension is clause 8. Okay, so it starts from clause 8.1, commencement date, right? And then it go on, so on and so forth. Then sub clause 8.5, when it comes to sub clause 8.5, we are talking about in FIDIC 2017 version, it is sub clause 8.5, which is related to the extension of time. But in FIDIC 1999 version, it is clause 8.4, because clause 8.4 now has been supplanted with a new clause called advance warning and early warning, right? But however, in the FIDIC 2017 version, it is sub clause 8.4. So at a glance, you might see that it is a very easy task. You need to delete 2 clauses and you need to amend 2 sub clauses when you are going through, when you are changing a re-measurement contract to a lump sum contract, right? But there are a lot of things associated with that one. So in the next weeks, actually after 2 weeks, in a fortnight's time, we are going to discuss about the problems that we encountered, the lessons that we learned, and the questions that you have asked us. I'll give you structured answer to the questions that you have raised so far. Okay, you have raised. Let me just give them a little bit of an idea about that. Okay. Um, 1, 2, 3 questions have been asked, and I will be answering those questions in detail within my next session, right? So now, once again, coming back to FIDIC conditions of contract for construction, it is a little bit of a thick book, okay? If you're comparing that with the FIDIC 1999 version, when you go ahead with that particular book, it is like a novel, right? You will be explained about certain changes. There may be more definitions. Now, for instance, the number of defined terms has substantially increased in FIDIC 2017 version. Now we are going to focus about the special provisions which is being made within FIDIC Red Book 2017 version in order to change a remeasurement contract to a lump sum contract. So there are 2 deletions involved. Number 1 is the deletion of the second paragraph of subclause 8.5. I will explain this to you, right? Then the deletion of clause 12, measurements and valuations, totally deleted. Now, someone asked me what is the golden principle related that the quantities are not remeasured for the purpose of um, in lump sum contract. So in this part of the world, okay, then I have to tell you, because we are confining our discussion here for FIDIC Red Book, right? In this part of the world, that particular rule is based on this deletion of clause 12, right? And I will explain to you in depth when I'm explaining this particular clause to you, right? And then amendment to subclause 13.3.1. Then the relevant clause, understand there's a difference between a clause and a subclause. Okay, the relevant clauses are clause 8, that is commencement, delays and suspension. Clause 12, that is measurements and valuations. Clause 13, that is variations and adjustments. And clause 14, contract price and payment. So these are the only 4 occasions where you need to do the changes if you are going to change a lump sum remeasurement contract to lump sum. Then a question will come into your mind, what about the contract data? Okay. Now the contract data has got certain provisions. If you go to the FIDIC Red Book, you will understand contract data has got certain provisions, certain places where you need to insert certain values. However, it is also driven by these clauses. So I may say the deletions and amendments has to be done to these particular clauses. And as I have told you before, in order to clear any ambiguity, in order to clear any sort of a clarity problem, we need to peruse the whole of the document to understand the occurrences of these particular clauses and their related provisions. So those things I will be explaining to you within the next session, right? So again, coming back, there are 2 deletions and 2 amendments within the FIDIC Red Book, which you need to do in order to have a robust, clear, and concise um, lump sum contract. The good news is FIDIC 1999 version has got the same thing, but there are certain differences that I will be explaining to you, right? So that the users of FIDIC 1999 and SPD2 also can adapt whatever these changes, whatever the notions, and whatever the ideas which I am giving to you when you are drafting a lump sum contract. Okay. Now let us go into the deletion of the second paragraph of subpoint 2. Right. Actually, I have solved this one before that one because this contract price thing is of very much importance. Now you might have remembered right now Oman conditions of contract, we also have the same problem, but it's in a with a different terminology, right? Oman conditions of contract has got 2 different terms for the value at the time of the signing the contract and value which is changing over the period of the contract. What are the 2 terms which is appearing in Oman conditions of contract 1981 version is contract value and contract price. But if you go to FIDIC 1977 version and FIDIC 1987 version, they use the same term contract price for both these elements. That is at the time of signing the contract, also the contract price. Then at the time after within the execution of the contract as well. But if you go to the FIDIC 99 version, they introduced a new term called accepted contract amount, right? And the contract price remained the same as this changing thing. So the subclause 14.1 specifically talks about contract price. Now, if you take the general conditions of contract in isolation, if you take the general conditions of contract in isolation, there is only one place you will see the word lump sum. It is appearing within the contract price, subclause 4.14.1, item C2. It says, for the purposes of clause 12, measurement and valuation, and the contractor shall, and D means the other clause, the contractor shall submit to the engineer within 28 days after the commencement date a proposed breakdown of each lump sum price. So this has nothing to do with the lump sum contract. Okay, that we know whenever there is a price in the BOQ says LS or lump sum, you put a price for that one. This is basically appearing within the what you call preliminaries portion, right? So you do a breakdown for that one. When you are doing a breakdown for that particular lump sum, right? At the time of tendering, you're asking this from the contractor. Please give us this particular breakdown of this lump sum, because in order for you to comprehend, right? This is from the eyes of a cost consultant. In order for you to comprehend whether it is worth to pay the contractor this particular lump sum. Okay, maybe at the time of the variation, executing a variation, you should be knowing what are the things which is there, not to sort of misuse the values which is given by the contractor, but in order to comprehend that. So that is why it is there. So therefore, this is of no significance. But when it comes to the special provisions, as I have told you, the paragraph which is needed to be changed, right? In the subclause 14.1. Now I am going back to what I have stated. Amendments to subclause 14.1, contract price and payment. Okay. So this is the amendment which needs to be done to the contract price when you are changing a remeasurement contract to a lump sum contract. So now let us understand what is given in the remeasurement contract. It says the contract price shall be the value of the works in accordance with subclause 20.3. Now you can link something. You understand, whenever the word subclause 12, starting from 12 comes up into play, definitely you have to change that one, because you deleted clause 12.3. Sorry, you deleted the clause 12 when it comes to the lump sum contract. So needless to say, it is understood this needs to be changed, right? So this is how the FIDIC has approached that one. This is why we need to be mindful. That is why you need to be mindful, contract administrators, when you are drafting a lump sum contract based on a remeasurement contract. You will definitely have to look into the occurrences of subclause 12. Okay, all the occurrences of subclause 12 will have a knock-on effect on changing a remeasurement contract to a lump sum contract, right? This is of utmost importance that you need to understand, right? And it says, and be subjected to adjustments, additions, including cost or cost plus profit. Now, cost plus profit is a word which was introduced for the first time in FIDIC 2017 version. Okay, this particular defined term was not there within FIDIC 1999 version or SBD 2, right? So they have done a session about this dice of cost plus profit. I think some of you have attended that one. So that is why they use the word cost plus profit. Now, if you go to the FIDIC 99 version or SBD 2 version, this particular term is not there for deletion. Okay, it is a different term. But anyway, we are going to discuss about that as well. To which the contractor is entitled under these conditions and or deductions in accordance with the contract. So this is the clause that we are going to delete. Then what are you going to add? The contract price shall be the lump sum accepted contract amount. So this particular terminology from here to here, right, shall be the value of the works in accordance with blah blah blah, all these things, right, has been changed to the contract price shall be the lump sum accepted contract amount and be subject to adjustments in accordance with the contract, right? So subject to adjustments in accordance with the contract, think about it. What does that mean, right? Then it says any quantities which may be set out in the bill of quantities or the schedules are estimated quantities and are not to be taken as actual and correct quantities. This is given in subclause 14.1 of FIDIC 2017 version. Of the works which the contractor is required to execute or for the purpose of clause 12. Once again it appears. Okay. So now I have simplified you the exercise. Now you know wherever clause 412 or subclauses of that one comes into play, you need to amend them, right? It does not necessarily say that you need to delete all of them, right? But you need to amend them. Now, upon completion of today's session, you are getting the know-how about how you are going to change the drafting of the contract. Upon completion of the next session, you will elevate yourself from that knowledge basis to practice and advice. These are the 3 tiers of RICS in order to achieve the chartership, the charter status, to become a chartered quantity surveyor, what you should be doing, right? Now see what has been changed. Any quantities which may be set out in a schedule are estimated quantities and are not to be taken as actual and correct quantities for the works which the contractor is required to execute, right? So any quantities which may be set out in a schedule are estimated quantities and are not to be taken as the actual and correct quantities of the works which the contractor is required to execute. Now they are talking about, right? They are talking about any of the quantities which is mentioned within the lump sum type of a contract are cannot be taken into account actual and quantities of the works which the contractor is required to execute. So this is specifically mentioned in item C, which gives the ground for that particular term which I spoken to you, right? And then it talks about a little bit of a guideline has been given in these special provisions. This is an exact extract from the FIDIC 2017 version. It says lump sum contracts may be, okay, may, it is discretional, okay, suitable if the tender documents include details which are sufficiently complete for construction, that I told you, right? And for significant variation to be unlikely from the information supplied in the tender documents, the contractor can prepare any other details necessary and construct the works without having to refer back to the engineer for clarification or further information. However, as noted in the introduction above, that they are talking about a small introduction, if significant design input by the contractor is required, it is recommended that the employer consider using FIDIC's condition of contract for plant and build design build second edition. Okay, so it talks about yellow book as well. We are going to talk about that as well in the next session, right? Now, I spoke about up to the subclause 14.1 change only because the others I will have a small time issue. I don't want to stop at the middle, right? Now, what we have done is what we have covered the amendment to the subclause 14.1, okay, related to this one. Tomorrow you will be getting this particular presentation. I need to do some amendments, and then based on that, you will get to know about the other clauses as well. Now මම දැන් සිංහලෙන් ඉතාම කෙටියෙන් පැහැදිලි කරනවා නම් රීමෙෂර්මන්ට් කන්ට්‍රැක්ට් එකක් ලම්සම් කන්ට්‍රැක්ට් එකක් කරන්න නම් අපි බලන්න අවශ්‍ය ක්ලෝසස් හතරක් ගැන කතා කරනවා. ක්ලෝසස් කියලා කියන්නේ cluster of sub clauses. එක පළවෙනි එක තමයි clause 8 කියන එක. මොකද්ද? commencement, delays and suspension කියන එක, right? ඒකේ තියෙන clauses වගේක් අපි කතා කරනවා. ස්පෙෂලි ඔය 8.5 කියලා කියන්නේ extension of time clause එක. ඒ clause එකේ කිසියම් දෙයක් සඳහන් වෙලා තියෙනවා remeasurement contract එකක 110කට වැඩිය quantities තියෙනවා නම් ඒක critical part එකේ තියෙනවා නම් contractor eligible for extension of time. ඒ කැලල සම්පූර්ණයෙන්ම අයින් කරලා තියෙනවා lump sum contract එක. මොකද quantity risk එක දැන් තියෙන්නේ contractor ගේ අතේ. එතකොට contractor provision එකක් නැති වෙලා යනවා. claim ground for claim එකක් නැති වෙලා යනවා. අන්න ඒ type variations වලින් quantity changes වලින් variations කියලා අපිට කියන්න බෑ. quantity changes වලින් extension of time එක ලබා ගන්න. ඊට අමතරව clause 2 කියන එක clause 12 කියන එක measurement and valuation කියන එක සම්පූර්ණයෙන්ම eradicate කරලා සම්පූර්ණයෙන්ම අයින් කරලා තියෙනවා. මොකද ඒකේ කතා කරන්නේ හැමතිස්සෙම remeasurement එකක් ගැන. හැමතිස්සෙම valuation එකක් කරන method එකක් ගැන. නමුත් දැන් question mark එකක් ඕගොල්ලන්ට එන්න පුළුවන්. එහෙමනම් valuation කොහොමද කරන්නේ lump sum contract එක? අපි ඒ ගැන ඉතාමත්ම සවිස්තරාත්මකව කතා කරනවා ඊළඟ session එකේ. ඊළඟට අපි කතා කරනවා amendment to subclause 13.3.1 variations and adjustments. ඒකෙත් එක්තරා තැනක අපි වෙනස්කමක් කරලා තියෙනවා. ඒ වෙනස මොකද්ද කියලා කියන්න. දැන් එක්තරා මහත්මයෙක් මගෙන් අහලා තිබුණා මේ value engineering clause එක ගැන. ඒ අනිවාර්යෙන් ඒකත් මම කතා කරනවා. මේකේ අපිට තව question එකක් අහලා තියෙනවා. If you can share with us the recorded video of the presentation, it's appreciated. අනිවාර්යෙන්ම අපි ඒක share කරගන්නවා. ඒ ගැන worry වෙන්න එපා. Right? Thank you for the question. ඔයගොල්ලෝ questions අහන තරමට තමයි මට මේ feedback එක පිළිබඳ idea එකක් එන්නේ. මොකද හේතුව නැත්නම් මම ඇත්තටම ස්තුතිවන්ත වෙනවා මේ අහන ප්‍රශ්න වලට. question අහන තරමට තමයි මේක තවදුරටත් iron out වෙන්නේ. මේක two way learning process එකක්. So මමත් ඉගෙන ගන්නවා සමහර ලාවට මේ ඔයගොල්ලන්ට මේ presentation කරන්න යද්දි. ඒක නිසා මේක ඊටම වැදගත් අපි මේ යන ගමන, right? එතකොට ඊට අමතරව අපි කතා කරනවා මේ contract price and payment එකේ තියෙන වෙනස්කම ගැනත් අපි කතා කරනවා. ඒකත් ඊටම වැදගත්. ඒක මේ අපි මේ අනිවාර්යයෙන්ම ඒක ගැන සම්පූර්ණයෙන්ම කතා කරනවා. දැන් අපි අද දවසේ අපි ඉගෙනගත්ත දේවල් සම්බන්ධයෙන් කතා කරන්න ගියොත් උඩටම ගියොත් right? අපි plan කරගෙන හිටියේ අද lump sum contract එකක් පිළිබඳ අවබෝධයක් ලබා ගන්න. Understanding lump sum contracts and their definitions එක අපි කතා කරා. Comparison of lump sum contracts with other procurement and payment mechanism අපි ඒක ගැනත් කතා කරා. අපි target cost එක ගැන කතා කරා, guaranteed maximum price එක ගැන කතා කරා, remeasurement ගැන කතා කරා, management contracts ගැන කතා කරා, ඒවා කතා කරා. ඊට අමතරව අපි case study එකක් කතා කරා cost value reconciliation. කොහොමද cost value reconciliation එක කරද්දී ඒක මේ lump sum contract එකකදී සහ remeasurement contract එකකදී quantity survey එක ගැන බලන්න පුළුවන් ඕන විදිය ඒ දෙක අතර වෙනසක් තියෙනවා. ඒක අපි කතා කරා. ඊට පස්සේ අපි red book එකේ තියෙන features applicable to lump sum contract ගැන අපි කෙටියෙන් කතා කරා. අපි ඒක සවිස්තරාත්මකව කතා කරනවා දෙවෙනි දවසේදී. ඊට පස්සේ FIDIC red book 2017 එක version එක use කරලා අපි lump sum contract එක draft කරන එක. මේක තමයි අපේ ultimate aim එක. ඒක ගැනත් අපි කොහොමද කරන්න කියන එක පිළිබඳව යම් තාක් දුරකට කතා කරා. ඊට පස්සේ brushing up some areas of RIC's core technical competency commercial management in construction. අපි එතනදිත් කතා කරා මේ කොහොමද cost value reconciliation එකක් commercial management in construction කරද්දී අපි cost එක කොහොමද benchmark කරන්නේ. අපි කාරණා තුනක් ගැන කතා කරා. cost to complete ඒ අමතරව එනේ earn value management කියන එක සම්බන්ධයි. ඉතින් මේක තමයි අපි සාරාංශය. So thank you very much for attending today's session, and I believe that you have gained something, and we are embarking on a journey that towards mindful contract administration. That's what I wanted to tell you, right? Definitely all your questions will be answered within the next session, and if you are not satisfied with the answer, you can email me, you can contact me, you have my number and all these things, right? And you will be getting this presentation by tomorrow itself. I will assure that one. So you can go through all of them before coming to the next session. So you can ask a lot of questions, right? And that's it. Thank you very much, and have a pleasant evening, and good night.
Thank you, Priyanka. Good night.
Okay.